Good morning. Happy Wednesday. Welcome to the Courtroom Files Live. Yes, Barbara, I'm dating us with that music. Just the slow, smooth jazz sounds to get you started. Let's start our morning off with Judge McNally. It's a busy morning out there in the courts.
And that was on April the 22nd. So I want to read the plea agreement into the record again, if I can, if you'll give me a minute. And everybody sign this, and here's what it says. Defendant will enter pleas to OWI second and an added count of driving on a suspended. Sentence recommendation of 60 to 90 days jail is determined by the judge with work release if eligible and available. This jail condition may be waived at the discretion of the court if the defendant completes a specialty court program pursuant to statute. The OWI 3 charges will be dismissed at sentencing, provided the terms of the agreement are satisfied. A sentence of agreement of 2 years probation with sobriety, drug veterans, or mental health court that the defendant will need to find placement on or before sentencing. No early termination of the probation. Any SCAO-approved sobriety or specialty court will be acceptable. The 33rd District Court has an acceptable program. That's nice of them to tell me that. In addition, all the terms set by the court, costs of prosecution of a minimum of $500 or more is determined in alcohol, drug screening, treatment, full restitution for any out-of-pocket costs for damages or harm incurred because of the offense on or before sentencing, if applicable. So I want to make sure, do we have the vehicle owner here that should have been notified? If you just give me 1 second here. We did send a letter to Gary Ennis Jr. on April the 22nd and also to Jason Glenn. This was a parked car, right? Is this not a parked car, or am I confusing this one? I'm just asking you. Can you tell me, Mr. Shemke?
The car was parked, I believe.
Yeah, I'm just curious as to why they notified 2 separate owners. Let me just double check something. Yeah, Unit 2, that's you. Was traveling northbound. I'm sorry, Unit 1 struck, that's you. Unit 3, which was parked on the street. I don't know why they, at any rate, I don't need to deal with that. I'm concerned he's got 3 priors. Granted, none of them have happened in the last 24 years. I'll give him that, 25 years, but still it's a 4th offense. I'll listen to anything you have to say, and we'll go from there.
Yes, Your Honor. In the circumstance, I'd like you to reflect that he has done extremely well on bond. He has a strong family support system. He has remained gainfully employed. Judge, he had used poor judgment. He was trying to assist a friend, and he found himself in this predicament. But I will say, as far as a client goes, any instructions that I give him, he's always been able to follow without any sort of issue. He's already been in treatment. Any sort of request or order that's been put in place by the court, my client has not hesitated to comply with 100% accuracy. It's because of that, Judge, and how well he's done on bond and the strides he's made with his life in the past few years, besides having this notation, I'd ask for jail to be waived at this time, honestly, to consider if there were to be a violation, but he's very eager to demonstrate full compliance with the sobriety court. He appears timely, very respectful, and I think that he's going to demonstrate an outstanding effort in the program, Your Honor.
Anything you'd like to say?
Yes, I just, I know I made a bad mistake, bad judgment, but looking forward, I want to just, get this behind me, and I'll do whatever I have to do to make things right.
I don't know if I've ever had a 4th offender that I didn't send to jail, to be honest with you. I'm a drunk driver. I can't think of one. It's possible, but I don't know that I have. 2 years probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol. No illegal drugs, no marijuana. You're not to purchase, possess, or consume those. You're not to go to any place where alcohol is sold or dispensed. You're to submit to chemical testing, PBTs, and ETGs when probation tells you to, when you know how often you have to test. You're to submit the PBTs, ETGs, and chemical testing on demand of probation. Like I said, you're to complete 60 days more on the SoberLink device from this date. But we will get that turned around. It'll be now covered by our grant. You're to attend 12-step meetings 3 times per week and provide written proof of attendance. You're to obtain an AANA 12-step sponsor. You're to attend all substance abuse treatment at an approved facility and provide written proof. You're to attend the Victims Impact Panel. You're to attend and complete the Armed Specialty Program. You're to report to sobriety court status review hearings with me every 2 weeks. You're to obtain and maintain employment and provide us with proof. Now, I'm going to talk about the fines. There was an agreement of $500, so I'm going to honor that. 200 fines, 500 costs, 75 victim's rights fee, $50 justice assessment, 8 1/4. Screening fee is 60 for 885. Probation fees are 480, bringing the total to 1365. Sobriety court probation fees, sobriety court fees are 360, bringing your total to $1,725. I'm coming back to that. You do have to pay, and I feel badly about this, but there's only so much I can do. Cost of recovery on this case is $150. So your total's $1,875. Now, I don't know what to do with you, Mr. Blisman. I don't usually come out here and say that. I don't. I mean, there's times I don't know exactly which direction I want to go, but just give me a minute, please. All right. I'm gonna do this one a little different. I'm gonna give you 200 fines, cost 500, that's per the agreement. $75 victim's rights fee, $50 justice assessment fee. $60 screening fee, $480 in probation fees, $360 in sobriety court fees. There's cost of recovery of $150. I'm going to order that you serve 90 days jail, and that will be deferred. You're going to serve, I'm giving you credit for 1 day served. You're to serve 6 days on the court work program and pay $210 for that. That's your first 6 plus the 1 day credit. You're going to complete 4 days of community service. I'm going to give you all the way until September 1st to complete that. That's 32 hours. We're going to have review hearing dates. And by the way, your total now fines and costs, including the court work program fees, you know, with the $500 minimum cost, I don't know why they're putting that in there, but I'm going to honor it. It's $2,085, and I feel terrible about that, but I can't really do any better. I mean, these are all fees that are associated with the program. So it's 11 days jail now. Credit 1, serve 6 on the court work, 4 days community service. I'm giving you until September 1 to complete your community service. 79 days are deferred. You're to appear for a review hearing date. Lisa, I want you to give them a review hearing date every 4 months for me to determine if the defendant should have to serve the jail then. And here's the bottom line. You do everything. You cross all your T's. You dot all your I's. I'm not going to end up sending you to jail on this, and that's significant. I know that the other ones are old, but you still have 4 of these. Now, the last one was 20 years ago or so, whatever I said, but I'm going to do that. But, I mean, I'm giving you credit. You're doing well so far. I'm glad to see that they're not hamstringing me on these probation sobriety court cases. They're, you know, some could criticize. That's okay. But if you violate 365, and I'm telling you, I will give you the 365 days if you don't make it through the program. But I hope your goal here is not to make it through the program, it's to gain lifelong sobriety. Restitution, if any, will be handled through civil litigation. None of the names I mentioned are here, correct, Lisa?
I have a Motorola that just popped in that I can't identify.
Well, let's bring them in and or her in, whoever it is, and I'll ask them. How's that? So I'm going to do this for you, Mr. Blisman. Not that you don't deserve it, but it has been a long time, and we do make mistakes, and you've shown that you're, to me at least, that you're accepting responsibility, you're remorseful, you've done what we've asked you to do. So I'm going to be more reasonable here, or reasonable to the extent I should be. Let's put it that way. Motorola, can you tell us your name, please? You have to show up with your name on there, please. What's your name? Motorola Moto G Power 55G 2023. What's your name? Start your video and tell me your name, please. Motorola G. Moto, if you better call, I don't know your name, sir, and you have to use, or ma'am, what's your name?
Judge, that's Stephen Bailey.
Okay, good
Yeah,
enough.
we're good.
So that's what we're doing. Can you pay all this today, or do you need time?
Payment plan,
How much do you have today?
$1,000.
Okay.
Judge, I think there's a count too also.
Yeah, I know. I got to go on to that. You pay $1,000 on this, and then the balance, I'm just going to let you pay at the rate of $100 bi-weekly. Can you do that?
Yes, sir.
Pay that $100 bi-weekly. We'll start that. I'll give you some little bit of leeway time. 6/13/20 is the 27th of Friday, right, Lisa? Of June?
Yes.
Okay, so that's what we'll do on that one. I don't really have a register. Give me the other file. I'm gonna go light on, or I just need another page of a register. for count 2, like a first page. I'm just gonna fine you on that. I'll go light. 50 fines, 50 costs, 75 victim's rights fee, $50 justice assessment, 2 1/4, or 90 days, okay? Okay, sir? So here's what I'll do. Do you think that you can pay this, say before your first payment's due on the drunk driving?
Yeah, I pay this.
I'll tell you what, let's just do this. I'm gonna make it easier. All right. On the drunk driving charge, we're only going to have you pay $775 now, okay? So that'll be $775 on that case, and you're also gonna pay the suspend, so you pay both. Pay $775, you pay the suspend charge of $225, and then you pay $775 on the drunk driving, OWI 2, and then you just stick with that payment plan of $100 bi-weekly starting June 27th. Again, no problem if you need more time. I'll be glad to give it to you. You'll meet with probation. They might not need to talk to you, but since we had status reviews this morning, okay? I wish you well. Stay with me on this, please. Good luck.
Did you say review dates every 4 months?
Correct, and I'm gonna let you just set those up. with
Okay.
them. Yeah. Okay, thanks. Thanks. Silvana, Barry, you're all set. 25W8388569. Does he have a lawyer?
Let's leave Judge McNally and then take a tally of judges named Ronald or judges named Sally. On finding not one single judge but a 0, let's go to Judge Mom, our favoritist hero.
All right, before we wait the formal reading, after plea of not guilty for the purpose of the arraignment and as to the pretrial counsel.
Your Honor, discuss this matter with Mr. Dahl as well as with the prosecuting attorney. It's my understanding that in return for a plea of guilty to no operator's license on possession and a plea to responsible for the expired plate, the original charges of driving while license suspended, as well as the no insurance, would be dismissed. I've explained to him his constitutional rights. He understands those constitutional rights. He understands that by entering into these plea agreement that he will be waiving certain of those rights. Also, Your Honor, he understands the sanctions with respect to these driving while license suspended or the no operator's license on possession. And at this time, he wishes to avail himself of that plea opportunity. There are no immigration issues, Your Honor.
Okay, sir, please raise your right hand. You solemnly swear or affirm the testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
Yes, Your Honor.
You also have heard the plea that your attorney placed on the record. You may lower your hand.
Yes, Your Honor.
And as to the amended charge of no operator's license on person, how do you plead?
Guilty, Your Honor.
As to the count of expired plate, how do you plead? Responsible or not responsible?
Responsible.
And you've gone over your advice of rights and you understand all those rights, correct?
Yes, Your Honor.
And you also understand you'll be waiving some of those rights by continuing with your plea.
Yes, Your Honor.
And you understand the possible penalty as a result of your plea, whether in this court, any other court or administrative agency.
Yes, Your Honor.
Knowing all that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way if you enter into a plea?
No, Your Honor.
And any immigration issues?
No, Your Honor.
Counsel, if you can please party your client.
Thank you. Mr. Dahl, on March 14th of 2025, were you operating a motor vehicle in the city of Wyandotte?
Yes, sir.
And at that point in time, at some point in time, did you come in contact with the Wyandotte police officers?
Yes, sir.
And when they asked you to provide them with a valid operator's license, you were unable to do so. Is that correct?
Yes, sir.
And that's because you didn't have a valid operator's license on you at that time. Is that correct?
Yes, sir.
And also, the vehicle that you were driving had expired plates on it. Is that correct?
Yes,
So
sir.
you're pleading responsible to that as well.
Yes, I am.
Offense is satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the amended charge and as to the expired plate. And the court will dismiss the original charges per the plea agreement. And counsel as to sentencing.
Thank you, Your Honor. Mr. Dahl had a number of outstanding tickets. There were no outstanding warrants, and he has made efforts to pay them off. I believe that he has a total of approximately 5 or 6 tickets. He has in contact to pay those tickets, that's all it is. It's not a warrant outstanding. He realizes that he can't operate a motor vehicle until with these on his record. We're asking for immediate sentencing of course and fines in this particular matter.
All right, and sir, what's the current status of your license?
Suspended.
How'd you get here today?
I got dropped off.
Well, why were you driving on March 14th?
All these related traffic are because I had to go to work, so I just needed to make, I just need to get the tickets paid and work with Salter during the winter. I just need to get them paid and I'm okay until I get rides and get picked up or Uber, so I can.
Well, sir, I understand that it's a cycle, right? Like, what comes first, the chicken or the egg, right? You have tickets to pay, you have to get to work so you can pay those tickets, but you don't have the right to drive. So you need to make sure you're getting rides places, sir.
Yes, sir.
It may seem minimal, but it's still a criminal misdemeanor. Right, whether it's a traffic misdemeanor or otherwise, it's still something you have to take care of. And it's still against the law to drive without a valid license.
Yes, sir.
And so you're sure you didn't drive here today?
Yes. I get picked up by my grandmother.
Do you have any car keys in your pockets?
But yeah,
Why do you have car keys in your pockets if you don't have the right to drive?
well, I mean, I've. Good question.
That's why I asked it.
I have other vehicles, but yeah, I mean, not drive. I mean, it's hard. I'm gonna be honest. Like, I have children, and it's super hard. I mean, just pay my tickets, and I'll be fine. Like, all my tickets are in my work truck, so my work truck only drives to work.
But your work truck can't drive to work if you're the operator of that car, that truck.
Yes, I understand.
And if I recall, don't you do general construction type work?
Yes, sir.
And you work for yourself?
Yes, sir.
So don't you think it'd be cheaper to hire a driver?
Maybe, yes.
And so what type of work truck do you have?
F-350.
And that work truck is not out in the parking lot?
No, it's not.
What other vehicles do you drive?
A Jeep Cherokee, SRT, a GMC Terrain, a Ford Explorer,
And so none of those vehicles are out in the parking lot?
GMC Terrain is your high.
Right. Because you didn't get dropped off. You're not taking those off. And the car keys are in your pocket because you drove here today. So don't lie to me and tell me that you didn't. Because you think it's gonna sound better.
Yes, sir.
Because I know better, sir, and I know you've been here a number of times and that I was fairly confident that you did in fact drive here. So what's your plan? Because you're not driving out of this parking lot.
My grandmother's actually waiting for me to wind up. We have a situation to take care of, and I can just have her come pick me up.
Good idea. In the meantime, you're gonna leave your keys here until you have somebody that can come, a licensed driver that can drive your vehicle,
Okay.
okay?
Yes, sir.
And where are the tickets that you have to pay? Where are they out of?
I got one in Riverview. My truck was parked outside.
Oh,
and,
that's here.
yeah, they gave me a park, and my plate was expired. I wasn't driving, but I got a couple other, one in Roseville, one in Battle Creek, and that's in Lincoln Park, and that's pretty much it.
Okay, so how much do you owe, sir?
It should just be like 250 each ticket or something like that. It's just, they just gave me kind of like misdemeanors. This is the only time when
Any civil infractions?
yeah, yes, sir. This is the only time where I've been pulled over and it's gone to this extent.
So what are your plans to make those payments, sir, so you have a valid ticket or a valid license?
I plan to go on Monday and just pay all of them.
Why haven't you done that so far? That's my question.
Honestly, I've been really busy and, you know, this situation is new, so, I mean, I don't really have a choice. I just need to pay them and be done with it.
Right?
But I
Right,
wouldn't be here if I would have just paid my tickets, honestly.
correct.
So I just need to go pay them and be done.
When you say you have to go pay them, how are you going to do that?
I can just pay them online.
Okay. So here's what the court's going to order. The court's going to order a $400 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50. That's total $725 plus the $100 for the expired plate. So the total is $825. You did post a bond of $500, so the balance here is $325. So I'm going to do, sir, is I'm going to indicate that $500 is payable today because we can apply the bond. And on your balance of $325, I'm going to give you until July 11th, okay? To pay that in full.
Yes,
That
sir.
gives you time to, because quite frankly, your priority is to pay the other tickets so you can get your license cleared.
Yes,
And then can you do the $325 by July 11th?
yes.
Take out your keys, you don't have to take your house keys off if your house keys are on there.
Just a single key.
Okay, so I'm gonna have you leave it here with the court officer with your name and phone number, so that we can then, once you have somebody that's here, the licensed driver to here to come pick it up, then you can have them, they get the key and you can have them drive it, wherever they have to drive it,
Yes, sir.
okay? All right. All right. We'll, hopefully only see you back because you're with somebody that's coming to pick up your car.
Yes.
All right, good luck to you, sir.
Thank you.
All right, have a good day.
Okay, thank you, Your Honor.
Thank you.
Mayor Pro Tem. Okay.
All right, let's head south a little bit and say good morning to Judge Anna Marie Anzalone, who appears to have a bunch of people in orange lined up.
Your device in the hallway and start your video. I'll send your request. Go ahead and just click on it. There you go. And I'm going to send you a request to start your video now. And then I'm going to put you in a breakout room with Mr. Malaro. And then when you're done, just leave it on because I'll probably use it again. All right. Go ahead and join that breakout room. All right, Mr. Fry, I have somebody. I have Mr. Marvin, right? Mr. Marvin?
Yes, ma'am.
Okay. Let me grab your paperwork. All right, this is in the matter of the people of the state of Michigan versus Chad Thomas Marvin. We have multiple files. We have file number 25-22272FH. We have file number 25-22239FH and 25-22259FH. So I have Isaac Sneed appearing on behalf of the people, and I have Brian Fry appearing on behalf of Mr. Marvin. Hold on, let me get there. So we have a pretrial on file number 25-22239, as well as 25-22259FH, and then we have an arraignment on file number 25-22272FH. So, Mr. Fry, do you waive the reading of the felony information on 25-22272FH?
Yes, Your Honor, we'd waive the reading and ask the court to enter not guilty plea on behalf of my client.
All right, and I will do so. And you have received a copy of the felony information prosecutor's request for discovery and witness list.
Yes, Your Honor.
All right, and how would you like to proceed today then, Mr. Marvin?
So, Your Honor, if possible, could I talk to Mr. Marvin in a breakout room? Miss Adams
Yep.
just sent me a bench warrant, I guess, and I wasn't aware of it.
Oh, yep. Okay. Yep, there is a bench warrant on file number 25-22239FH for failure to drug test 3 times a week at Lenawee drug testing facility after being released from jail on April 28 of 25. So, yep. All right, so I'm gonna open up a breakout room for you both. So hold on a second. Just a minute, hold on. All right, so Mr. Marvin is in room number 1. And Mr. Fry, I had to close a bunch of rooms. All right, go ahead and join that breakout room. Mr. Marvin. All right, so back on the record with Miss Fonseca. So Miss Fonseca, why don't you come back up? All right, Mr. Malaro, have you had an opportunity now to speak with Miss Fonseca?
Of course, the video, there we go. Yes, I have, Your Honor.
How would you like to proceed?
Your Honor, I believe we have reached a resolution of this matter. The resolution is as follows. Ms. Fonseca will be pleading guilty to the added count 3 of the amended information, attempted possession of a loaded firearm in a motor vehicle pursuant to 750.227C, a 1-year misdemeanor, and then pursuant to 750.239, that is mandatory forfeiture. And then counts 1 and 2 would be dismissed at the time of sentencing. There's a further agreement of no immediate jail. I don't believe there's restitution, but if there is, it would be determined by the court. And I believe that involves the plea agreement that we've reached today.
So I have count 3 and 4 asterisk. She's pleading both of those?
I'm sorry,
or
yes.
just
Sorry, yes, count 3 and count 4, attempted possession.
All right, and so Mr. Sneed, I just have a quick question. It shows that the high court misdemeanor 1 year, and the laws probably changed. I thought high court misdemeanors were 2 years. Like 1 years too?
Well, with the attempt, it makes it a 1 year.
Because it's the attempt, okay. And you said no upfront jail. And Mr. Sneed, is that correct? Plead guilty to count 3 and count 4 and no upfront jail?
It is, and I know there is a written plea agreement that's been provided to Mr. Valero. I don't know if the court has received that signed yet.
I do not have that yet, but that's okay. Any other sentencing agreements?
No, thank you.
Not from the defense, Judge, no.
Ms. Fonseca, you want to, is it Fonseca? Fonseca. Fonseca. All right, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? I do. Now, Ms. Fonseca, you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 3 attempted weapons, firearms, possession of a loaded firearm in or upon a vehicle which carries a maximum penalty of up to 1 year in jail and or a $1,250 fine? Though it does require mandatory forfeiture of a weapon or device. So is it your intention to plead guilty to that count?
Yes.
And then is it your intention to plead guilty to count 4, which is the same charge, attempted weapons, firearms, possession of a loaded firearm in or upon a vehicle, which also is a high court misdemeanor, which carries up to 1 year in jail and or $1,250 fine, and mandatory forfeiture of a weapon. So is it your intention to plead guilty to both of those counts? Do you understand that there's a plea agreement that there would be no upfront jail in this case? Speak louder for me.
Okay,
Okay. Are you satisfied with your attorney and the advice that he's given you?
yes,
All right. Do you, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court? Is that correct, Mr. Malaro?
That is correct, Your Honor.
Mr. Steen?
Yes, Your Honor.
And Ms. Fonseca, as far as you're aware, is that correct?
yes.
All right. If a guilty plea is accepted, there will be no trial. And Ms. Adams, I will need an advice of rights form from Ms. Fonseca. Neither the if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. We're also going to give you a written copy of these, and I'm going to ask you to sign it just to acknowledge you've read it and understand your rights, okay? All right, you have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Hold on one second, Ms. Adams. I'm also going to need one over to the jail for Mr. Graves and Mr. Renner to sign today too. Thank you. They're in a room already. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
So the laws change. So do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. So for example, if you get in trouble or get arrested on a new charge, that no upfront jail agreement would go out the window and you wouldn't, as you used to be able to, have a right to withdraw your plea. Do you understand that?
Yeah.
Okay. Misconduct is defined to include, but is not limited to, absconding or failure to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So I'm going to pause here, and my bailiff's going to bring down to your advice of rights. I want you to read through it and then sign it. Today's date is May 28th. And Mr. Renner and Mr. Graves, we will get a copy over to the jail now for you guys to look through. All right, so did you get a chance to read through it?
Yes, ma'am.
And you understand it?
Yes.
And you signed it?
Yes.
Thank you so much. And I'm going to put that advice of rights into the file. So thank you, Ms. Fonseca. So do you have any questions about the rights that I've given to you?
Not at the moment.
Okay, so Ms. Fonseca, how do you wish to plead? to count 3, the charge that on or about September 16 of 2024, that you were in the city of Adrian in the county of Lenawee, and that you committed the offense of attempted weapons, firearms, possession of a loaded firearm in or upon a vehicle. And there are 2 counts. How do you plead to each count? Guilty or not guilty?
Guilty, Your Honor.
All right, and one of them was a Smith & Wesson SD 40, and one was a CW 45 KAHR. Is that correct?
Yes,
And that would constitute both counts. So you plead guilty to both counts,
Yes,
ma'am? All right. Has anyone made any threats or promises to you to induce you to plead guilty to these counts?
no,
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Milaro,
No, Your Honor.
Mr. Steen?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be other than the no upfront jail? So in terms of fines, costs, or anything like that? Speak up a little bit.
No, thank you.
Okay.
Sorry, no, ma'am.
It's okay. It's okay. Is it your own choice to plead guilty?
Yes,
All right. So Ms. Fonseca, on September 16th of 2024, were you in the city of Adrian in the county of Lenawee?
yes.
Okay. And were you driving a vehicle?
It was parked.
It was parked.
Yeah.
Were you in the vehicle?
Yes,
Okay. Was anybody else in the vehicle with you?
not at the moment, no.
Okay. And somewhere in that vehicle was a Smith & Wesson. Where was that weapon?
I believe it was in the,
Between the seats?
in the compartment.
Oh, in the little compartment between the seats? Whose car was that?
Mine.
We need the yes or no.
Okay, so it was yours and it was in the compartment between the seats, yes?
Yes, ma'am.
Okay, and would you agree that would be concealed?
Yes,
Did you have, okay, and then that would be count 3. Under count 4, did you also have a KHR weapon?
yes.
Where was that weapon?
That was in the vehicle as well.
Where in the vehicle?
And it was in the bag.
In a bag?
Yeah, like a duffel bag.
A duffel bag? Was it in the front seat, the back seat, the trunk?
In the back.
It was like on the floorboard between the back seat and the front seat? Say yes.
Yes, sorry.
Okay, all right. And would you agree that weapon was concealed?
Yes,
Were both of those loaded?
yes.
Okay. And do you have a concealed pistol license?
No, ma'am.
Okay,
I was in the process of that.
okay. Are the people satisfied?
Yes, thank you.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Milaro?
Court has, yes.
All right, and Mr. Steen?
Yes, thank you, Your Honor.
All right, Mr. Milaro, can you repeat that?
The court has, yes, the court has.
Okay, thank you. I don't remember now, I just like backtrack, and I asked, has the court complied, correct?
Right.
Yeah, I did, Joanne.
Yes, you did,
Okay.
yes.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Milaro, are you available for sentencings on July 11 at 8:15?
Yes, I am available.
All right, so Ms. Fonseca, do you wish to appear in person or via Zoom?
Probably in person.
Okay, so I'll put you in person. And all right, so Ms. Fonseca, I am going to send you right across the hall to the probation department. I want you to go in there, I want you to check in. They're gonna get some information from you and they're gonna give you instructions going forward. So I think they'll give you a packet to fill out and then a time and date to come back. It'll get your contact information, make sure your voicemail's set up. make sure you can access your voicemail because they'll leave an appointment time for you to come in. When you come in and meet with them, be truthful with them about your background, the events that occurred, and they'll prepare a pre-sentence report. We will provide a copy of that to Mr. Malaro a few weeks before sentencing. Make sure you reach out to him in advance of sentencing to review that with him. And then we'll see you back for sentencing on July 11 at 8:15. Miss Adams, could I get a notice of hearing from Miss Fonseca?
Judge, did she plead to misdemeanors?
Oh, shoot, never mind.
I know, I didn't want to interrupt you.
Yeah. I'm gonna take that all back. All right, we're gonna give you a notice of hearing for sentencing.
Sorry.
Next Thursday on, I looked at that high court and all right. So next, let's see, that would be June 5, a week from tomorrow. I need you to report to district court probation and talk to Mike McCarran, and he'll prepare a pre-sentence report and we'll get that to your attorney, okay? Okay, all right. So there's some law changes going on right now that will send these misdemeanors back down to district court anyway. So that'll be nice. All right, so Ms. Fonseca, have a seat. We'll get you a notice of hearing, and remember, a week from tomorrow, you report to district court probation, all right? Thank you.
All right, the busy morning continues out there. Lots of great court action. Let's go across Lake Michigan over to Wisconsin and say good morning to Judge Mogan.
Good, Your Honor. I'm just controlling the screen for Miss Bridges.
Oh, I appreciate it. Thank you. All right. Oh, are we ready? Okay, we will go on the record. 24 CF 138, State of Wisconsin versus Morgan Bridges. The state appears through District Attorney Kevin Schmidt in person. Ms. Bridges appears by video conferencing in custody. And her attorney, Ryan Reed, also appears by video. Ms. Bridges, you are in custody, I believe, somewhere in Minnesota. Is that correct?
Yes.
What county are you in custody?
Pine County.
Okay, you're in custody in Pine County, Minnesota. Mr. Reed, it appears, I believe that we have reached an agreement, or you and Ms. Bridges have reached an agreement with the state. Can you please recite the agreement for the record?
Thank you, Your Honor. I anticipate the state amending count 1 to possession of just amphetamine. And then the state would dismiss and read in count 2 and count 3. And then the court would quash the warrant, and I believe just court costs, Your Honor.
Just court costs. Basis for the agreement, Mr. Schmidt.
Yeah, she's done an AODA assessment and does show the severe substance abuse care. They have recommendations in there. She's in Minnesota. She's in custody there. It really makes more sense for Minnesota to be burdening her treatment rather than Wisconsin.
All right. Okay.
And I can also,
Ms. Bridges, go ahead, Ms. Reed.
I can also tell the court that once the warrant's quashed, Ms. Bridges will be going to an inpatient program through through either corrections or DOC in Minnesota.
Okay. Ms. Bridges, do you understand that if the court does accept this agreement and I do a costs only sentence in this matter, you have previously paid cash 2 times on 2 different occasions. One was in the amount of $500 and a second was in the amount of $250, but those payments of cash have already been forfeited and they're gone. Do you understand that?
Yes, Your Honor.
Do you understand that if I do follow a recommendation for costs only and that you are assessed costs, and if those costs are not paid, that the court will issue a warrant and you could sit time in jail? Do you understand that?
Yes, Your Honor.
All right. And I'm going to let you know, I'm not sure how familiar you are with this county and this court, but I really enforce costs. I make sure that these costs get paid. So do you understand that?
Yes, Your Honor.
How long have you been in custody in Pine County?
Since April 19th.
Since April 19th. All right. Okay. So I have in front of me a plea questionnaire waiver of rights form, and it appears, Ms. Bridges, that you signed this document. Did you in fact sign that document?
Yes, since I've been in here.
All right. Did your attorney go over that document with you thoroughly?
Yes,
Did he essentially read it to you word for word?
yes,
And you understand it completely?
yes,
So you're pleading guilty to an amended count of possession of amphetamine. Is that correct?
yes,
Formal motion to amend to a possession of amphetamine, Mr. Schmidt?
So made.
Granted. You're 33 years old, 10 years of schooling. You can read, write, you understand the English language, no drugs, alcohol, or medications, and no mental illnesses or disorders. Is that correct?
yes, Your Honor.
Because you're charged with crimes, you're entitled to constitutional rights, and each of those rights is listed on that document. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
You're pleading guilty today by video conferencing. Your attorney is appearing by video conferencing as well. Do you understand that you have a right to be here in person with all people in the same room?
Yes, Your Honor.
Are you asking the court to allow you to enter a plea and be sentenced by video today?
Yes, Your Honor.
If at any time you have any questions or concerns and you need to speak with your attorney, let me know and I'll send you into a confidential breakout session, okay?
Okay.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation? Do you understand that?
Yes,
Do you understand that the state would have to prove on or around June 2nd, 2024, that you possessed a substance? The substance was a controlled substance in an amphetamine classification, and that you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would have to prove?
yes,
You understand that the maximum possible penalty could be a fine of up to $5,000 or imprisonment of up to 1 year in the county jail or both.
yes, Your Honor.
Do you understand that there is a recommendation to the court of costs only? But do you understand I'm not bound to follow that recommendation?
Yes, Your Honor.
Said differently, I could sentence you all the way up to that maximum penalty if I thought it was warranted. Do you understand that?
Yes,
Now, did you go over that criminal complaint or the facts alleged in that complaint involving this case with your attorney?
yes, Your Honor.
For the most part, are those facts accurate?
Yes,
Are you admitting here today that you in fact did possess an illegally controlled substance in an amphetamine classification
yes, Your Honor.
and that you knew it was an illegally controlled substance?
Yes, Your Honor.
Mr. Reed, may the court use the probable cause section of the criminal complaint to find a factual basis?
No objection, Your Honor.
Ms. Bridges, has anyone made any threats or promises to you for you to enter a plea here today?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes,
Has your attorney represented you competently?
yes, Your Honor.
Has he answered all of your questions?
Yes,
Has he looked at this matter thoroughly?
yes,
Are you satisfied with his services?
yes.
Any questions for the court or for your attorney before we proceed?
No, Your Honor.
As to the amended count 1, possession of amphetamine, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'll find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the amended count. The other counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
The reason for this agreement is she's missed court a few times. She's forfeited cash. She's in Minnesota right now. She did the Rule 25 there. She gave honest answers there that categorized her in a level where she's going to get treatment. Once this is lifted, she can go do the treatment. It will be in Minnesota where she's currently, I believe, when she did the Rule 25 indicated she was homeless. If we did probation transferring there, the burden of that, the encumbrance of having Wisconsin probation tying her here could actually interfere with her rehabilitation. And since this is just a substance abuse crime, nothing else, it wouldn't make sense to do that. Thank you.
All right, thank you. Mr. Reed?
Thank you, Your Honor. I would first join with what the state has said on the record. I can also represent that Ms. Bridges has been very dutiful in contacting me and working with me and giving me the information I needed. So I believe the joint recommendation is appropriate and ask the court follow it.
Thank you. Ms. Bridges, do you care to make a statement here today? You don't have to, but it's your only opportunity.
No, Your Honor, I'm good.
Ms. Bridges, this is not the most serious case. This is definitely a use case. It tells me that you have substance abuse issues, and the fact that you're in custody in Pine County for similar related issues and you're waiting to go to treatment tells me that you, in fact, do have the substance abuse issues. This is not a dealing case. It's not a burglary case. You don't have connection to Burnett County. My community is not at risk. And as Mr. Schmidt indicated, that if you were to be placed on Wisconsin probation, it would in fact interfere and impede your ability to get the treatment and the help you need in Minnesota. So I do believe that the agreement is appropriate. So the court is going to assess costs only in this case. So what I'm going to do is I'm going to assess the DNA surcharge only of $200 for count one. So $200 DNA surcharge. And the reason why I am waiving the court costs and the additional fees in this case and only assessing the DNA surcharge is quite honestly because you've had $750 already forfeited. That is a lot of money. And I cannot waive the DNA surcharge. So I'm going to tell you that that's going to be something that you're going to need to pay. It's going to be, you're going to need to come up with that and pay. So if you are picked up on a warrant and it's because you still have this owed, you will not get out of my custody until you figure out how to get that money paid. So you better figure that out, and that's going to be owed, and it's going to be here pretty soon. What I can do is give you a grace period, and I can give you a grace period of 3 months to get that paid. So I'll say $200 to be paid within 3 months, okay?
Okay.
But again, I'd be careful because otherwise the court will issue a warrant and you could sit up to 6 months, and the court would also be able to issue a civil judgment against you because you're always going to owe that. I'm ordering that your DNA be collected. We do need that on file. You have the ability to request it be expunged from the system through a written letter to the Wisconsin Department of Justice, not to this court, to the Wisconsin Department of Justice. I believe that covers everything. Mr. Schmidt.
Nothing further from me.
Mr. Reed.
Nothing further, Your Honor. Thank you.
All right, thank you. Then we are adjourned.
Thank you.
All right, I just put up a poll. Let me know your thoughts. Will this person get her life turned around? I personally hope she does, but let me know your thoughts. Let's, where do I want to go? Let's go back to Judge McNally.
Ma'am, Ms. Lawler, you can come up to that microphone. That is a microphone again. Sir, your name?
Derek Allen, Cannabis.
Counsel?
Thank you for representing.
We have two charges here. Failure to clear all warrants. They say he cleared, but then he got another charge that he didn't appear on, and he has a warrant outstanding. And two, failure to refrain from having contact with the victim. Ma'am, your name?
Danielle Lawler.
How is he going to proceed on these?
Your Honor, my client will plead guilty to both of the explanation.
Is that right, sir? Is that what you want to do?
Yes, Your Honor.
If you plead guilty here, I want you to understand you have 7 technical violations. Your probation could be revoked. You could be incarcerated on this. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights?
Yes, Your Honor.
And you could get the maximum. Do you understand that?
Yes, Your Honor.
Did you read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
Your name is O'Donnell?
We have our location.
You understand everything here?
Yes.
You understand if you plead guilty, you're waiving your right to a hearing?
Yes.
Is the count one that you failed to clear all warrants? Again, you did as you were supposed to, but then allowed another one to occur. How do you plead to that?
Guilty.
Did you fail to clear all of your warrants, well, let me put it to you this way. Did you acquire a warrant after you cleared them and then not clear that one?
Yes, I didn't have the money fully paid, but it's paid.
Sir.
Yes,
Is the count 2 that you failed to refrain from having contact with Danielle Lawler, being within 2 miles of her and her residence, how do you plead?
guilty.
Did you come within 2 miles of her residence?
Yes, Your Honor.
Did you call her?
No,
Did you talk to her?
no,
Did you appear at her doorstep?
no,
Anybody force you to plead guilty?
no.
All right, so I'm gonna accept your plea to count 1, failure to clear all warrants, and 2, violation of the no contact, at least the order not to be within 2 miles of her. What happened? Can you tell me, Ms. Warren, or Ms. Lawler?
Yeah, so I was made aware that there would be a play date between my daughter and one of her school friends who lives 3 to 4 blocks away from my house. Play date has happened there before, however, it was not Derek who took her, it was Lori, which was fine.
Who's Lori?
His wife.
Okay,
And there was no incidents that day, the play date went fine, he wasn't present, Ellie confirmed that he wasn't present. I found out a few days before this violation occurred that there would be another play date. I assumed it would go just the way it went before, where Lori would be the one taking her there and he would not be present. He did send me a message for that first play date, confirming that he knew he should not be there because of the no contact order. So for the second play date, I assumed it would be the same. However, when I went to pick up Ellie that night at 6 p.m., I did witness them sitting, so we drop off at the Trenton Police Department when she comes back to me. I pulled up to the police station approximately 10 minutes to 6, and they were sitting in the back of
who's they?
Ellie, Derek, and Dory. In the back of the car with the hatch up, eating ice cream from Custard Corner. And that's something he said that he's been wanting to do, is get Custard Corner. When Ellie got in the car with me, she talked to me about the play date, and I did confirm that Derek was present the entire day at the friend's house. I verified where the friend's house was again with her, just to make sure there was no mistake. He was present for the play date and then stayed in the area to go to Custard Corner until drop off.
All right. So he didn't have any direct contact with you. He took his daughter to a location that's less than 2 miles away. You said, did you say a few blocks, right?
Yes.
But he didn't call you, other than that first time, text you to say, hey, I'm going there on a play date. It's a violation of the court's order.
No, he stated that he would not be there because he knew he couldn't
Right.
be that close.
Why are you doing that if you know it's a violation of the court's order?
That was a different location play date that I knew. I wasn't aware until we got this play date, how close we are, and I should have left.
Your Honor, again, these are 2 different incidents.
I know.
The one that he said he thought would be a violation, he believed that proximity would have been a violation. The issue with this last one, he was taking his child to a birthday party, my understanding, his wife was driving, they didn't think he was within this area. So he thought it was okay for him to go, so he went, had a birthday party, he left. So again, he understands that technically, upon being aware of the proximity, it is a violation, he wants to take responsibility for
You
that.
know how to use Google Maps, right?
My wife, I should have, as soon as we got
So
there.
all you have to do is put in her address where she lives and put in the address where you're going and figure out how far it is.
That's what we did. Now we have a radius bubble, so I know exactly for sure.
And Your Honor, we would like to draw to the court's attention, again, hoping that my client isn't incarcerated, is gainfully employed. Your Honor, I want the court to reconsider how it fashions this particular order, because effectively, he can't really parent his child. He can't take his child to school because of that proximity to 2 miles. He can't take her to dance class or any activities. He effectively will have no parenting time. And as you can see, based on both these violations, he's not actually trying to have contact with the victim or anything. He's trying to be a parent, a father to his child. So if there's a way we fashion this moving forward, the court could forgive him and understand his circumstance, it would help him out a lot. And the other violation, Your Honor,
Something bothered me here when I sentenced him, I can tell you that. Go ahead, I'm sorry.
The other violation, Your Honor, my client cleared all the warrants as he was supposed to, his last word about the court. This additional matter came up. My client submits, and I have personal understanding of this. He was led to believe that he had paid everything off on the ticket down to 36th District Court. Sometimes the court, because of its busyness and its huge administration, can get things a little confusing. There can be a miscommunication, even within his own ranks. He walked out and thought he had paid it. But then he came to be aware there was this small balance he still had to pay. So that popped up new to him after he thought he had cleared everything and was in compliance. As soon as he was aware that, okay, he owed another $100, he went down there and paid it, Your Honor.
Judge, if I could, on that warrant, that 36th District Court warrant, he did clear it on September 19th originally. He was then scheduled for a hearing as a pretrial hearing, like most cases would be. He didn't show for that hearing. That's why the warrant was then reissued. Also, he owes a balance of $290, so it wasn't a small balance that was owed on that. That has since been cleared at this point. He does owe a balance. They've given him till July to pay that balance as of today.
So it's been cleared, Your Honor.
How far do you live from the victim?
I live in Suffolk.
I'm just asking miles away.
I think 10, 15 miles, I'm not sure exactly.
Who has custody primarily, you? So I want you to understand something. When I put these protections in place, I'm doing it for the benefit of the victim, okay? But the intent behind it is that he not be allowed to call you, text you, drive by your house, be some wise guy like that. It's not that he not be able to bring his daughter to a party that happens to be within 2 miles of your residence, or bring her other places. I want you to understand. And again, you've not been a model probationer. I don't know what's going on with you, Mr. Makunovich. You got 7 violations since August.
That started out very bad, but.
Well, we're not gonna get along good if you come back in front of me again. I'm promising you that.
Understood.
I hope you do.
Yes.
So I'm just telling you, that's my intent. These are not the biggest violations I've ever seen. So I'm not gonna do it. I'm accepting his pleas. I'm gonna not require any additional costs, even though I could certainly justify that.
Judge, could I just make one comment though, just because when the victim Danielle issued the police report, she said that this incident would happen on April 23rd of 2025. The day after that, April 24th of 2025, Derek emailed me asking for the court's, Judge McNally's order, stated he needed them because he wanted to file a police report against Danielle, the victim on this case, because he believed that she drove past his house, and he believes that she broke that no contact order because he believes she drove past his house. I stated to him that the no contact order is not for him, is for him to not be near her, and again, could he necessarily prove that she drove past his house or not? So again, I do believe that Derek is very aware of the no contact, and he's very aware he's not supposed to be in 2 miles. I know it's difficult being that they share a child, but these are the consequences of Derek's actions.
You know, those are totally different circumstances.
Well,
She came by, he misunderstood what the protective order did, but what he was even alleging was that she came too close to him. What we're talking about is he was trying to parent his child. So
again, I think the timing of it though, the day after the incident happened, I think he was very much aware that he broke the no contact order on that day.
I don't think there's any question that based on what I've heard, that he knew it was violating the no contact provision. I mean, maybe not. I'm not gonna go into this. And when I say violated the no contact, he violated the zone within which he could drive. I'm not condoning his conduct. I'm not condoning your conduct at all. You don't get to violate judge's orders. That being said, the intent of the order was not so that you couldn't drive your child or be at your child's play date, so to speak, that's located within 2 miles of the victim's residence. That was never the intent. So I'm going to go ahead, I'm not going to impose costs, probation order modified. You're not to have direct or indirect contact with the victim. Requirement that he not be within 2 miles of the victim or residence or place of employment is deleted. Now, I want you to listen to me. Don't start puffing your chest over this one. I'm giving you a break.
Thank you, Your Honor.
I'm telling you, don't go near that lady. You drive, if I find out you're driving down the street, and by the way, when you start making comments about what the judge's order should be or not be, or is, I don't tell victims they can't have contact. If she called you on the phone, the fact that you could pick up the phone and talk to her, that's a violation by you, not her. Okay? Stay away from her. Except as I've got in this order. I wrote down here, no contact with Daniel Lauer except in conjunction with circuit court. Can't read my own writing here. I think I wrote circuit court procedure, I don't know. But the point is, you two, you, Mr. Makunovich, something bothered me here. I mean, something bothered me. So I'm gonna let this go, but don't get to thinking that I'm gonna order her not to have contact with you, and don't get to thinking that don't read any more into this as it is. If there's a violation of no contact provision, you're going to jail. Okay?
Okay.
That's it. Have a nice day. Thank you very much. Good luck. Thank you, Ms. Lawler. I appreciate it. Michelle Rosalie Shock, 25T711721. Detective, your name?
Detective Corporal Sean Chapaniak, Trent Police Department.
Raise your right hand. Solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Go ahead.
On Friday, May 23rd, 2025, at approximately 22:25 hours, Corporal Blake Rusnick was monitoring traffic on Fort Street and Harrison Ave in the city of Trenton, County of Wayne, when he observed a gray Ford Escape bearing Michigan registration plates Edward William David 5467 in the right travel lane going approximately 35 miles an hour, failing to maintain their name. The vehicle proceeded west on Belmont Road, then north on Medford Road, when he observed the center brake late light to be inoperable. Corporal Rusnick made a traffic stop on Medford Road, just north of Belmont Road, where he made contact with the white female driver, identified by her Michigan identification card as Michelle Rosalie Shock, 76 of 94. Shock was advised for the reason of the stop and ran through lien/SOS and came back suspended with 3 prior convictions. Shock was removed from the vehicle and pursuant to department policy, an inventory search of the vehicle was conducted by Corporal Rusnick, where he located a teal hip-hop box in Shock's backpack. Corporal Rusnick inquired about the contents in the container, and Shock stated that inside was her methadone. There is a small slit in the top of the box, and Corporal Rusnick could observe chorboy and folded tinfoil believed to be narcotics. Shock advised there was heroin inside the teal box. Upon opening the teal box, Corporal Rusnick located a few folded up bundles of tinfoil believed to be narcotics, which were later confirmed to be fentanyl. Also located was a silver brass knuckle folding knife in the side pouch of Shock's backpack. Shock was advised she was under arrest and asked if she had any more contraband on her person. Shock voluntarily retrieved 2 used hypodermic needles, 1 crack pipe, and a large cellophane baggie, which contained several 1x1 bags of a white rock-like substance and several tinfoil bundles of a white powdery substance. The evidence was collected, and Shock was transported to the Trent Police Station by Patrolman Jonathan Lippa and Patrol Car 1109, where she was booked and housed. Corporal Rusnick field tested the white rock-like substance in the clear 1x1 baggies using the Dectachem mobile test kit and received a positive confirmation for crack cocaine. Corporal Rusnick also field tested the white powdery substance in the tinfoil bundles using the same mobile test tech. Positive confirmation for fentanyl. The total combined weight was approximately 14 grams. In total, 12 bags of crack cocaine and 24 bundles of fentanyl were collected.
Hang on a second. Lisa, where am I hearing that feedback from? Is there, do you know?
That's from Trenton, I believe.
All right, ask him to just, go ahead, detective.
Hold on 1 second. Go ahead, Your Honor.
What's that?
Go ahead, Your Honor. So his thing is he doesn't.
Who's talking back there?
My partner's on the phone with another person. He's trying to get her off the line right now. We had a call come upstairs.
Was the defendant's license suspended or revoked?
Yes, Your Honor.
Did the defendant have the prior conviction building with intent January 4/19?
Yes, Your Honor.
I just want to make sure. So we got in the metallic knuckles, the defendant had possession, correct?
Correct, Your Honor.
Based on your sworn testimony, when authorized in all 4 counts, I find they've been made, I find that there's probable cause to believe those crimes were committed and defendant committed those crimes, and there's sufficient evidence on the record for the second offense notice. I'm going to authorize. You're all set. We'll put the warrant into lien. Thank you very much. Have a good day. Thank you.
Thank you, Your Honor.
Sarah Renee Diaz, 25W837198.
Let's switch it up and go back to Judge DeSanto.
You have received a citation regarding mandatory school attendance education neglect, correct? I'm sorry?
Yes.
And you spoke to the prosecuting attorney today?
Yes.
And the prosecuting attorney indicates you're going to be responsible, correct?
Yes.
Please raise your right hand. You solemnly swear or affirm the testimony about to give this matter the truth, the whole truth, and nothing but the truth?
Yes.
All right. And as to the allegation, ma'am, how do you plead, responsible or not responsible?
Responsible.
And you understand you do have the right to have a contested hearing in this matter. By entering into a plea, you will not have that contested hearing.
Yeah.
Is that yes?
Yes, yes.
Okay. And you understand the possible penalty as a result of your plea today, correct?
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Okay, and so, the court will accept your plea as knowing and voluntary, and so what's going on with attendance with your child?
Liam is diagnosed with mild cerebral palsy. They had a diagnosis like spasticity and abnormal gait. He sees Center for Exceptional Families every 2 months for doctor's appointments, but he also sees them for physical therapy to check on he wears orthotics. To basically check on the sizing of the orthotics to make sure they still fit correctly. They do a permanent note for school for these, so that way I'm not constantly having to get the doctor's note when he isn't there. Other school districts have recognized it, but Wyandotte won't, and I didn't know that. I just assumed it followed him, because I never had problems in the past. I assumed the note followed him to every school that he has, gone to. But they don't, so. I don't have doctor's notes because I thought this would have been it.
Oh, okay.
Yeah.
Okay. All right, well, how's he doing with school?
Oh, he's good. He's got an IEP, so he struggles with math, but other than that, he's good.
Okay, and what grade is he in?
6th.
Okay. All right, so what's your plan for next school year?
We're moving to North Branch.
Okay. Well,
Yeah.
You don't have to bring that this way. All right. $50 fine, can you pay that today?
Yeah.
All right, good luck on your move, good luck next year with school, and hopefully your son's doing well.
All right, thanks.
All right, just stop at the window, thank you. All right, we're on the record in the matter of the city of Wyandotte versus Dante Riley, 25359.
Good morning, Your Honor. Rami Hijazi, P82830, on behalf of Dante Riley, who's here standing to my right. Can you state your full name for the judge, please? Dante Riley.
All right, good morning to you both. And so today is the date scheduled for the arraignment pre-trial in this matter, and counsel adds to the arraignment.
Your Honor, would be waiving formal reading, and my client would like the court to enter a not guilty plea on his behalf, please.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then adds to the pre-trial counsel.
Your Honor, we are requesting 30 days just so we can get some discovery. I believe the proposed discovery order is in the file right now. If you would sign that, I'll take it upstairs and get that request.
Yes, the court has signed the discovery order, and we will adjourn this to, we can do June 25th.
Let me just take a look, Your Honor. That is a good day for me.
Okay, in the afternoon, we'll give you the the time in just one moment.
At 1:45.
Okay.
1:45 p.m. And then as to bond counsel.
Your Honor, my client is gainfully employed in the community, he works at the hospital like right across the street. Had a one-off day.
Hospital? We don't have a hospital across the street.
Or, sorry.
The one at the hospital?
Yeah, sorry.
Okay.
Your Honor, so it is a one-off for him. He's retained me from the outside of this case. I don't believe there's any risk of him evading court in the future. Very eager to put this past him. I would request that we just do a personal bond in this matter, and we promise to reappear on time.
Okay, and so, sir, if you were to test right now, what is in your system?
Negative, nothing.
Okay, and you've never failed to appear in court for any reason?
This is my first time being in court, so no.
Okay, and so then you're not on probation or parole anywhere out on bond in any other jurisdiction, correct?
Correct.
All right. Okay, and so the court's going to continue your cash bond. You did post a cash bond, so the court will continue your cash bond. And then you're not to possess or consuming alcohol or drugs unless prescribed, and then we'll see you back on June 25th.
Thank you, Your Honor. I appreciate your time this morning.
Just have a seat for one moment. You'll receive a copy of your bond conditions, counsel, you get a copy of your discovery order.
Awesome.
Thank you.
Thank you.
All right. We are on the record in the matter of the city of Wyandotte versus David Boyles, 25383.
Attorney Corey Westmoreland appearing on behalf of Mr. Boyles. Mr. Boyles, would you please state your name for the record? David Boyles.
All right, thank you, and good morning. Today's date scheduled for the arraignment and pretrial in this matter, and as to the arraignment.
Yes, Your Honor, at this time we are prepared to waive the formal reading. My client stands mute.
The court will waive the formal reading, enter plea of not guilty for purpose of the arraignment, and as to the pretrial counsel.
Yes, Your Honor, at this time the city attorney has offered to amend the original reckless driving to one count of careless driving, and my client would like to avail himself of that offer and enter a responsible plea.
So your attorney worked out a very good deal for you. Please raise your right hand. Do you solemnly swear from the testimony about to give this man the truth, the whole truth, and nothing but the truth?
Yes.
You heard the plea that your attorney placed on the record, correct?
Yeah.
Is that yes?
Yes, ma'am.
As to the amended charge of careless driving, how do you plead, responsible or not responsible?
Responsible.
You've gone over your advice and rights with your attorney, correct?
Yeah.
Is that yes?
Yes.
And you understand all of those rights?
Yes.
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
Knowing all that, you must continue with your plea.
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, the court will accept your plea as knowing and voluntary and dismiss the original charge per the plea agreement, and that's $200, so you have that to pay today, or I'm sorry, you have a bond that you posted, so we can apply your bond. And then just stop at the window, sir, and in the event that there's any money that would be sent back to you, that would we have your information to mail the check, which we do monthly, okay?
Have a great
All right,
night. Thank you.
sir, thank you. And we are on the.
All right, let's switch it up again and take a look at something that we haven't looked at here before on the channel. This is El Paso, Texas. This is their jail magistrate court. So let's give that a try.
Currently is charged and held for evading arrest or detention with a motor vehicle. His current bond is set at $50,000. Miss Calhoun for the state of Texas and Miss Cavado for the defense. Miss Cavado.
Thank you, Judge. Your Honor, Mr. Munoz lives at 13036 Sparks with his mother. He's lived his entire life here in El Paso. He indicated that he went to El Paso Community College where he studied welding. He has his mother, his brother, aunts, and uncles here in El Paso, and he works at Mr. Car Wash. He has about $500 that he can post. He can be reached at 915-219-3961. He is respectfully requesting bond reduction or split bonds, whatever relief, if any, the court should find fitting. Thank you, Judge.
Thank you, ma'am. Ms. Calhoun?
Thank you, Judge. I just see pending cases here. And for the facts of the case, this is a traffic stop. The defendant evaded driving at 140 miles per hour. Eventually, the officer lost visual of the defendant. And then a couple days later at 11 p.m., the defendant was observed and he was stopped for speeding. And that's when he admitted to evading the day prior and said he ran because he was scared.
Was he out on bond for another offense at the time of this offense, this alleged offense?
I am not sure about that. I'm not sure if the PR bond office might be
Okay, and I will ask
better
them,
suited
but
for
I
yeah.
asked because I see a PG2 1 to 4 grams, but Miss Taylor, was he on a PR bond?
He's not currently on a PR bond, Judge.
Was he released on a PR bond May 18th or so?
Let me check for
Okay.
you, Judge. And what day did you say again, Judge?
Roughly May 18th, May 19th of this year.
No.
Okay.
He was not released on a PR.
Okay. All right. Thank you. All right, so he did post a surety bond on May 19th. He was released on May 19th of this year on a $1,500 surety bond. But based upon the nature and circumstance of the offense and for the safety of the community, I'm going to deny any relief at this time. All right, thank you, sir. He may be excused.
Fully? Darius, anything?
Next up, I have Germanis Finnegan.
Can I get your name and date of birth, sir?
Germanis Robert Finnegan, 9/30 of 1980.
All right, sir. State of Texas versus Germanis Robert Finnegan. The defendant is currently being held on a prohibited substance in a correctional facility. His bond is set at $10,000. Ms. Calhoun for the state of Texas, Ms. Cavato for the defense. Ms. Cavato.
Thank you, Judge. I'm so sorry. I missed the name.
Finnegan. And it's on the page, bottom of page 2.
Your Honor, Mr. Finnegan indicated that he was at the multi-use facility. He's been here in El Paso for about 2 months. He is from Palm Springs, California.
No, no. I'm from Odessa, Texas.
Okay. Well, sorry. Mr. Finnegan is from Odessa, Texas. He indicated that he completed up to the 10th grade in Palm Springs, California. He has no family here in El Paso. He does not have any money that he can post. He was released here in El Paso on parole. He is asking for a PR bond or any relief the court might find fitting. Thank you, Judge.
Thank you. Ms. Calhoun?
Thank you, Judge. There's quite a few out of county stuff I don't have disposition for, but he does have assault, family violence, conviction, assault, theft of service, theft, evading, and a couple thefts actually.
Since when?
And yeah, so that's and then as for the facts of the case, this is Mr. Finnegan. Okay, 1 second. This is where defendant was found inside a correctional facility. Basically, when they were doing rounds, he had THC.
A THC vape, is that what he's alleged to have had?
Yes. Yeah.
Okay.
Vape pen. Yes. Yes,
Okay.
Your Honor.
All right. I'm going to go ahead and do a $10,000 PR under enhanced level supervision, no illegal drugs or alcohol, subject to UAs and BAs. May not leave El Paso County. Miss Taylor.
Thank you, Judge. Sir, do you have a personal phone number?
No, I don't. I was living at the halfway house and I was using the halfway house phone number.
Do you plan to go back to the halfway house?
If they allow me to. I mean,
Okay. Do you have a phone number for a friend or relative?
no, I don't. Like I told y'all when I first came in, y'all, I just barely got out of prison and I was sent to the halfway house and haven't had a chance to get a job, to get a phone or anything like that.
Do you have an email address?
No, I don't.
Okay. And then, thank you, sir. Thank you, Judge.
All right. Thank you, sir. You may be excused.
Judge, I'll be having to break off really quick. I'm gonna speak to the lockdown.
All right, let's go to Kansas. This is Judge Webster. I still have to make a graphic for her. Maybe we'll get that done today if we can.
We are on the record in case number 2023 TR 2208, State of Kansas versus Christopher Dean Monroe. Jared Regier appearing for the state. The defendant appears in person and pro se. This was one count of operating a motor vehicle without valid insurance, a diversion agreement was filed in this case. December 11th of 2024, an order revoking diversion and setting the case for trial on stipulated facts was filed. Notice of hearing for that trial on stipulated facts went out. December 30th of 2024, the case was called for trial on stipulated facts. Apparently, Mr. Monroe, you failed to appear at that time. So we can proceed at this time with the trial on stipulated facts, if you like, Mr. Monroe, or I can set that for another date. But I do see in your contract for diversion, there is an agreement that if your diversion is revoked for any reason, It will be on trial on stipulated facts. So do you wish to proceed at this time on that trial, sir?
Yes. Yes, Your Honor, yes.
Thank you, sir. I'm going to go back up and get your contract in full here. That a diversion agreement was filed December 22nd, 2023. And in that agreement, are you, it looks like, are you agreeing that you did file, or you did sign that contract, sir?
Yes, I did, yes.
Okay. And on page 3, there is a paragraph that says stipulation of facts if criminal proceedings on the complaint for which the defendant is requesting diversion are resumed for any reason, the trial or trials upon such complaint shall be on the record of the stipulation of facts, herein which the parties agree and understand consists of the following: the entire contents of the reports submitted by Butler County Sheriff's Office in case NTA 30005, including affidavits, written statements, and narrative reports prepared by law enforcement. These documents are incorporated by reference as if set forth fully herein. The facts stipulated to are summarized as follows. Count 1, on or about the 19th day of May, 2023 in Butler County, Kansas, Christopher Dean Monroe did then and there unlawfully and intentionally drive a motor vehicle upon a public highway or property open to use by the public and failed to provide proof of insurance upon demand by law enforcement officer. This is in violation of KSA 40-3104D first, no proof of insurance, a Class B misdemeanor. And it also, the document includes waiver of counsel throughout. So the court is finding that you have waived your right to counsel, that you have agreed to proceed on stipulation of facts. You are found guilty of the sole count of driving without proof of insurance, a B misdemeanor. We will proceed to sentencing recommendations, Mr. Regier.
Yes, Your Honor. As a preliminary matter, if the court is finding that the defendant has waived his right to counsel, do I have leave to journalize that in the journal entry from today's hearing?
You do.
Thank you, Your Honor. Your Honor, pursuant to page 2 of the agreement for pretrial diversion, item 5 would appear to refer to court costs in the amount of $108 and a fine of $300. The state is recommending that the court impose the same. The state is further recommending a suspended jail sentence of 120 days, subject to a non-reporting probationary period for a period of 6 months. I will, of course, defer to the court on any issues concerning repayment of the case, and if the defendant is entitled to receive credit for any payments already made in this case, absent the diversion fee.
Mr. Monroe, do you have anything you want to say before I determine your sentence? You don't have to, but you're welcome to if you like.
Not at the moment, no, but I do have, a couple questions on how an SR-22 works because I am on that right now.
Okay, that, sir, you'll have to either take up with an attorney or with the Department of Revenue, as they are the ones that require that. You can go online and probably find some answers to that, or contact an attorney who might be able to just give you some simple outright advice on that without charging you too much for it. But that's important that you know that for future purposes, for present and future purposes. At this time, Mr. Monroe, I will order that you pay the minimum fine allowed by law, and that is $300 as recommended by the state. I will also order that you pay court costs, $108, so the total due is $408. You will get credit if you've paid anything towards your fines and costs. Now, I'm not going to give you any credit for anything that was a diversion fee. or a diversion application fee, but if you paid anything on your costs and fees, you'll be credited for that. You also will be ordered a 120-day jail sentence, but that is suspended, provided you successfully complete a 6-month non-reporting probation. You will not have to see a probation officer. Your probation has 2 conditions. Number 1, do not violate any law for 6 months. Number 2, pay the 408. How much time do you have or need to pay that, sir?
Is there a certain time that I have to pay it, or I can pay it as, soon as possible if that's what is recommended?
Well, I'll work with you on payment. It says you owe 408 on your diversion, so it looks like you haven't probably made any payments on your fines and costs. I usually go in increments 30, 60, 90 days. I gave someone 120 a while ago, but I urge you to make payments as you go on that. So how much time do you realistically think with your work situation or your financial situation you would need to pay that? Or let me ask you this, how much per month can you pay on it?
No. Oh, I could pay the whole thing off at once.
Oh, can you pay that today?
Probably not today, but I do get paid Friday. I would be missing out on rent, but I
I
could,
don't want you to miss out on rent. I can give you some time.
okay, because I got rent coming up.
Yeah.
And then the next check after that, because I don't own any vehicle right now. I'm just on off-road insurance. So that whole check could go to paying that. So,
Well, I'm going to give you 120 days to pay.
okay,
And I want you to sit down before you leave the courthouse and figure out how much per month or every 2 weeks you can pay to get this paid off within 120 days.
okay,
Because if you don't get it paid, you can come back in here for revocation of probation. They can suspend your license. It can go to a private collection agent who will add about 40% more to it. I'm guessing at the 40 cents per percent, but something, whatever they normally would have for collection fees. So make sure, sir, that you sit down and get this taken care of so you don't end up here again.
do I pay this online?
You can stop by the clerk's office and they'll tell you all the different ways you can pay.
Okay, all righty. Thank you, Your Honor.
You're welcome. If you can pay anything today, do. If you don't, I understand, but let's make sure it doesn't do like the diversion and just get ignored.
Oh, I'll definitely get paid up. That's for sure.
All right. Let's see. So don't violate any laws. And I don't think we need to get picture and prints taken. I think that's been done. Mr. Regier, anything further we need to address?
Not on this matter, Judge.
All right. Thank you, Mr. Monroe. You're excused, but stop by the clerk's office and do take this seriously.
Thank you.
You're welcome. And keep that SR 22 in place too. That's part of the don't violate any laws. All
right. Am I good to go?
You're good to go.
All right. Thank you.
Okay, Judge, the next one I have coming up is Brian Ferrer.
With an F
I
for
also just learned something, Judge.
Well, I'm sure he's learned something, but let's move on. Go back to Judge McNally, see what's happening there.
354. 24B146879. 25B147836. I'm told she had a .17 on the PBT. Does she want to contest that? I don't know what I'm gonna do with you. I don't know what I'm going to do with you. I have no more answers on you. What are you doing to yourself? What kind of drugs?
Just alcohol right now.
Just alcohol. You have a .17 and you've been in here for 2 hours, right? When did you stop drinking?
Around 2.
My lord, you were up around a 3.0. Do you realize that? Well, I don't know. 0125, 7 hours. That's another 10. Closer to 3.0, 27, 28. Your name?
Caitlin Fuller Carmen, Brunswick Township.
I don't have a bond condition that she violated. Because these were trespass charges, there was no evidence that that at the time that I arraigned her, that she didn't that she used alcohol or didn't. So I'm gonna go ahead, you guys asked me to adjourn these trials, there's no way I can go on now. But I don't have a bond violation. So all I can tell you is you can take her to Judge Hesson and you can explain. I would have been happy to do, but I didn't have it as a bond violation. I didn't set that as a bond. So we'll set all these, Lisa, for next week, Monday. Apparently they're up for trial, but she needs to go in front of Judge Hesson on the bond violation. I don't think it's fair for me to be the one to do that when I didn't conduct that hearing, when I didn't have that as a condition. But it's 0.1770 he wrote down here, okay? That's it. Good luck. Go down in front of Judge Hesson. I'm really worried about you. And the thing is, I can't say I haven't tried. Good luck. Let's do Elger Lucky. I know you guys are busy back there and I haven't been able to get you in here. Elger Lucky. Elger Ivory Pierre Lucky, 22B1397938.
Good morning, Your Honor. Kimberly Bell, P44711. I'm appearing in the house on behalf of Mr. Lucky today.
Your name, sir? Are you here on this?
I am here on Inch, but I can go.
I need you to pull this file. All right, so defendant hasn't been here.
Yes, Your Honor.
We have multiple counts. He has 2 prior technical violations. He absconded. I have 6 counts. How's he going to proceed on these?
Your Honor, as I had indicated to you off the record, I was trying to get some more information as to the status of this file.
Well, the status is that he's blown us off for 3 years.
Right.
That's the status. I sentenced him May the 12th of 22. I don't know what else to tell you.
Well,
You can, no.
Okay.
Hang on. You can look at the probation violations. He's got 6 of them. They think he didn't attend his probation visit on October 13, that he didn't attend the court work program on October 5 of 22, that he didn't provide proof of completing 4 hours community service by October 10 of 22. He didn't even provide verification of attending and completing outpatient treatment. That he failed to refrain from consuming alcohol and controlled substance, testing positive for marijuana and alcohol back at a chemical test back on September 13 of 22. I don't know what else to tell you. I mean, you can look at the file. He pled impaired.
Your Honor, may I address you now?
No, you look at the file. I can only do this in one way. I don't do Cobb's pleas.
Okay.
He's got a big problem with me.
All right.
He's blown off the court for 3 years, and I don't appreciate it. So I know, he was running the Pentagon. I don't know what to tell you, seriously. I don't want to hear these excuses. He knows that I know if I told him I'd give him $5,000, he'd have been here 3 years ago.
Give me a chance to.
Yeah, take your time, but I don't get it. I just don't get some of these guys. I really don't. They just, guys and gals, think they don't have to show up for 3 years and then come in and pretend like it didn't happen.
He's not a bad.
Oh, I'm sure he's not. None of them are. Anybody who ignores a court for 3 years is about as respectful as, that's the way I feel about it. You can come back and prove to me I've been thinking wrong for 60 years. William Michael James, 23B726981. I need Mr. Crawford. If we got to give other things to other lawyers, but I got him with Mr. Inch, right?
Mazin is with, Mr. Inch.
These poor guys been waiting around and I can't get them in here.
Mr. Mazin sent to me.
No, not Mr. Mazin. I'm talking about Mr. Crawford's got him. So you can leave.
Okay.
come back with Mazen Gaith and Inch, and you can come back on the other one.
Mr. Gates said to me as he left that he was gonna join for Mr. Inch on Zoom because something about something in custody, but I was,
Mr. Inch is right there.
no.
I have MDOC here that needs to be handled before we lose them.
Okay, go ahead.
Arraignment.
What you said. Cross out.
All right, so William Michael James, 23B 726-981. Your name, sir?
William Michael James. Michael Crawford, representative.
All right. Before we go on, I'll just indicate that defendant has been on bond conditions. And we're going to accept them. So have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have had the opportunity to review the report with my client, Your Honor, and there are no material additions or deletions. We ask the court without recommendation as presented.
Anything that you would like to say on his behalf?
No, sir.
And you're done?
No, Your Honor.
Sir, I'm gonna be glad to take you, but you missed the test. We talked about its status review this morning.
Yes, sir.
Can't miss anymore.
I know.
I'm gonna let it go. I'm not gonna let it go next time.
Okay. I'm sorry about that.
Well, why'd you miss?
I overslept my alarm. And I woke up at 9:50.
You have an alarm clock?
Yeah, I used my phone.
Well, then how did it not go off?
I swear I was mad at myself for missing it.
The phone
I
was
don't mind.
defective? Is the phone defective? Did you set your alarm?
I set like 10 alarms. I set
10 alarms?
I said,
None of them went off?
I'm a heavy sleeper. so I accidentally
You
missed
should
them.
go buy a lottery ticket.
Yeah.
I mean, if you turned 10 alarms on and none of them came on,
I think they came on, but I think I slept on my phone, so that probably had something to do with this. I didn't hear it.
all right, now wait a second, you're making this worse. You set 10
sorry.
alarms,
Yeah.
either none of them went off, or all of them went off, or any combination thereof went off, and you slept through it?
Yes, sir.
Come on. Come on. What are you, Rip Van Winkle? I mean, come on. I mean, you gotta make sure this doesn't happen. Who do you live with again?
My parents.
Well, then you have them come wake you up.
My mom's over.
I saw her, she raised her hand. Don't miss again.
I won't. I promise.
There is nothing I find amusing about this. 2 years probation, be glad to take you. But that worries me. You cannot leave the state without the consent of the court or violate any law. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana either. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing on demand of probation. They're gonna tell you when you have to go. At least I'm gonna need his ownership record on this, please. No alcohol, no marijuana, no illegal drugs. Chemical testing on demand, submit the PBTs, ETGs, and chemical testing on demand of probation, complete 60 more days on the sober link, but we are going to switch that into our name, so we're paying the bill with our grant. Attend 12-step meetings 3 times a week and provide proof, obtain an AA/NA sponsor, attend all substance abuse treatment. Attend the Victims Impact Panel, attend and complete the Armed Specialty Program. Report to sobriety court status reviews with me every other week. Obtain and maintain employment with proof provided to the probation officer. Do you own that vehicle that was being operated on the date of that?
I do not, sir. That was my father's.
What do you mean was your father's?
It is my father's. Sorry.
Okay. Seven days jail, credit 1, serve 6. I'll let you serve those as follows. You're doing well on this otherwise. Serve 4 on the court work program, 2 days of community service. I'm gonna give you until August 1st to complete your 16 hours of community service. 4 days court work program, pay $105 for that. I'm sorry, $140 for that, $35 a day. Fines, fines $200, costs $300. 75 victims' rights fee, $50 justice assessment. So fines and costs are $6.25. Screening fees, $60 for $685. You have probation fees of $360. Bring your total to $1,045. $480 in probation fees. That brings it to $1,525 plus your court work program fees. Your total's $1,625. If you violate, your probation could be revoked. You could be incarcerated for 93 days with credit for 1 day served. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that?
Yes, sir.
Lisa, did you run that ownership?
Yep, give me 1 second. I have to grab it off the printer.
Take your time. So I would have to order your vehicle immobilized, but if you don't own it, I'm not ordering it. You didn't own it at the time of the accident. I'm sorry, at the time of the incident. All right. Does he have all this to pay?
No, Your Honor.
How much does he have today?
400.
Okay. All right.
Judge, it's registered to a Brian and Brittany Janes.
That's my sister and my father.
Okay. You pay $400 now. You are making $750 a week, gross or net, before or after tax.
That's after.
Who's is Tricia James? Is this your mother?
Yes,
Is
sir.
she gonna let you apply the bond or not? If you don't want to, you don't have to.
I'll apply the bond.
That's 5,000, 10%, I believe, Lisa. Or was it three? Let me see. I don't know if it's 5,000, 10% or 5,000 or 500 cash. But anyway, we're gonna say he pays $850 now. And then balance at the rate of, can you pay 50 a week? Balance at rate of 50 per week. I'll start that beginning on June the 21st, okay? If you need more time, no problem, call the court, we'll go on Zoom. I'll be glad to give you an extension. Any questions?
So today I just pay
$850.
$850.
You're gonna pay, you're gonna sign over the bond. I don't have proof here right now as to whether or not it's a 5,000, 10% or 500 cash.
It was a 10%, Judge.
So you have $450 plus your $450. I just made it $850. You want to pay the other $50, you can. Okay? And then you'll meet with probation. I wish you well. I hope we help you. Good luck.
Thank you.
Don't miss again. Make sure he gets the testing. Darren Joseph Gazabon.
Okie dokie, my friends, this is a logical place to leave it for today. I hope you all had fun. I know I did. On your way out the door, if you have not smashed the like button, please do so. The more likes these lives get, the more likely the algorithm is to show it to other people and bring new people in, so that's important. If you're not a channel subscriber, please consider doing that. We'd love to have you. And if you're not a channel member, definitely please consider doing that. It's very inexpensive. There's a link for it in the pinned chat. But we have fun specifically every day. Before this show, we do a pre-show. And it's something a little different every day. This morning, the channel members got to help determine some of the direction that we'll go moving forward. So there's a lot of good involvement and back and forth and all of that sort of thing. So yeah, we'll see you tomorrow, which is Thursday. Thursday already. Crazy how time is flying. 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early again for channel members. Go make yourselves a great day today. Take care. God bless. We'll see you tomorrow.